Hello. In the Philippines, it is an accepted principle that the schools are given ample discretion in the granting of honors for purposes of graduation. This is a part of academic freedom. However, this is not without a limitation. In one case, the Supreme Court said that the school's discretion on an academic matter may not be disturbed by the courts unless there is grave abuse of discretion. In other words, the limitation to academic freedom is grave abuse of discretion. To our law professor, Justice Yap, our panelist, Attorney Yap, good morning. I am Attorney Polito from the Prov Law Office, and together with me are my co-counsels coming from the same law office. It's Prov P. Polito, Perino, and Hongkon. R. Rado Rivera O. Ortiz. We are here to present our paper, Petition for Mandamus, which we would like to call Medalya, where we are going to draw the line between academic freedom and grave abuse of discretion. Discretion and freedom are vested in every academic institution. However, in the exercise of such right and freedom, the school is bound by the limitations and restrictions in the Constitution, in the laws, and the rules and regulations or even policies made by the school. This regulation of schools is even recognized in the Constitution. Section 4, paragraph 1 of Article 14 of the 1987 Constitution provides that the state shall reasonably supervise and regulate all educational institutions, the purpose of which is to prevent injustice to others. This morning, the question then is not whether or not there is limitation to academic freedom. The elephant in the room is, when is there grave abuse of discretion on the part of the school, and when should the court compel that school to do or perform its duties and functions? Later on, my co-counsels will answer the questions. First, what is Mandamus? Second, what is Mandamus applicable in this case? And finally, why should the court grant our petition? But before that, we give the floor to someone to share her story, a story of shattered dreams and broken hearts. Ladies and gentlemen, our client, the petitioner, Jennifer Lee. Justice for Petitioner Lee. Stop academic tyranny.
Thank you so much. Good morning, everyone. It is with a heavy heart that I am standing before you, but I am here today as I wanted to share my story. I am Jennifer Lee, and I was an enrollee or a student of the University of San Carlos. In the year 1978, I originally enrolled under the College of Architecture, and at the end of school year 1978-1979, I incurred an incomplete grade in my subject Architecture 121 and 2 failing grades in my subjects Architecture 122 and 123. The next school year, I shifted to a new course under the College of Commerce with majoring in accountancy. And because I told myself that my failures do not define me, I exerted effort, I exerted blood, sweat, and tears, and I was able to get good grades. I wanted to graduate with flying colors. That is why, with my good grades, I wrote a letter to the Dean of the College of Commerce. I wrote a letter to the Ministry of Education and Culture and Sports, and I wrote a letter to the University Registrar asking them to not include my grades in the computation of my general point average, as this is in consonance with the university policy. As under said policy, if I was able to get consent from my professors for the change of my grades, and that if said subjects are not credit subjects under my new prospectus in my new course, then this will not be included in the computation of my general point average. However, even with the approval of the university registrar, even with the approval of the Ministry of Education of Culture and Sports, and also with the approval of the Ministry of Education, Culture and Sports, Higher Education Division, through the Memorandum 1248, upon complying with the said requirements, on March 28, 1982, I was able to graduate, but without honors. I was beyond woeful because I exerted a lot of efforts, and this is a very sad thing for me because I exerted effort. And that is why I am here in front of you. I wrote again a letter to the Dean, to Dean Satore. I wrote that the office of the Dean allow me to graduate and to confer upon me the graduate honor cum laude. But instead of doing this, and instead of approving my request, she wrote a letter to MEX division and asking for the revocation of my change of grade. That is why I wrote again a letter to the president of the university asking to compel Dean Satori to allow me to graduate with honors. But even upon asking for a reconsideration upon denial of my request, the president still denied my request. That is why I am standing before you, sharing my story and asking and praying that a positive outcome may be given. Thank you so much.
Good morning. I'm Attorney Victor Leves. I'm Professor Victor Leves Jr. I'm a tenured professor in the University of San Carlos, and in the College of Architecture, and I have been teaching Architecture 121 for many years now. And I still recall Miss Jennifer Lee attending my class in the second semester of 1979. And she was a vivacious, smart, and diligent student. She attended classes regularly. She got good grades and complied with any requirements. She was not a problem. And I really thought she would be a promising architect, but sadly, she was really not interested that much. And well, those are things that are out of the realm of us teachers to ask, because we just keep on pouring on the container and we cannot change the nature of the container itself. So I gave her. So when I heard that she was planning to transfer with to the College of Commerce, I just gave her an incomplete grade, termed as an IC, and I would just like to first simply define what an IC is. It's basically when us teachers, we would like to, it's simply a placeholder in lieu of a grade that because of the student's failure to comply with certain academic requirements. So it would be unfair if we give a student a 5, especially if she has already complied with certain cases.
I'm sorry, Professor, I really have to cut you there, but did you submit the requirements?
Wait, I'm lost.
Did you submit the requirements as required by the memo coming from MEX?
Yes. When I changed the grade on March 22, because of the order of the MEX, I received another order by attorney. I received an order that it requires the submission of the class record. So I also complied with that within the time before the graduation. And if you ask me if my personal opinion in regards to Miss Jennifer Lee's case, I think that it really falls squarely within the student policy. So I think she should be able to graduate. Because we may be strict, I may be a strict professor, but I'm not defined by that. And the same way as my students, I think that they should also get what they deserve. So yeah.
Thank you, Professor Leves. And now we move on to my co-counsel. She will present to us what is Mandamus, Attorney Radok.
Thank you, Attorney. So I will just give a brief discussion on what is the remedy of Mandamus. So in the remedy of Mandamus, a writ is issued to compel a ministerial duty and leaves no room for the exercise of judgment. Now, it requires that the petitioner have a legal right and the respondent an imperative duty. It is simply a command wherein to exercise a power already possessed and to perform a duty already imposed. As to the grounds of Mandamus, so that it will issue, it is under Rule 65, Section 3 of the Rules of Court, that Mandamus will lie under any of the following cases. So there are 3 grounds. First is that it can lie against any tribunal which unlawfully neglects the performance of an act which the law specifically enjoins as a duty, in case any corporation, board, or person unlawfully neglects the performance of an act which the law enjoins as a duty resulting from an office, trust, or station. And lastly, in case any tribunal, corporation, board, or person unlawfully includes another from the use and enjoyment of a right or office to which such other is legally entitled, and there is no other plain, speedy, and adequate remedy in the ordinary course of law. Lastly, for the time in which it shall be filed 60 days from the notice of the judgment, order, or resolution, or from notice or denial of motion in case of motion for reconsideration. Thank you.
Good morning again, everyone. Under Section 5, Paragraph 3 of Article 14 of the Philippine Constitution, which provides that every citizen has a right to select a course of study of his choice. Likewise, under Section 5, Paragraph 2 of the same article, academic institutions are given academic freedom. It has a wide sphere of autonomy, certainly extending to the choice of student or to the discretion of formulating rules governing or granting the honors for purposes of graduation. However, such constitutional provision shall not be construed in a grudging fashion, because under our Constitution, academic institution must not exercise it with grave abuse of discretion. One of the provisions of USC's exercise of its academic freedom is its academic policy. The relevant provision of its academic policy is under Section 2.11, Article 2, and 2.12 of the same article. Under 2.11 of Article 2, which states that
the change of grade from 5 to withdrawn be allowed, provided that these requirements are present, that the concerned professor of the particular subject consented to the change of the grade in question, and the student shifted to another program, and the subject in question is not a credit course included in the new program prospectus. Under Section 2.12, which provides that a change of grade from IC may be had anytime, even after the lapse of 1 year completion period, provided the following are shown. Number 1, the concerned professor of the particular subject consented to the change of the grade in question, and that the student complied with all the requirements of the subject, and that the student shifted to a new course. As discussed by our client, Ms. Jennifer Seeley, she was able to comply with the requirements provided under Section 2.11 and Section 2.12 of Article 2 of the Policy of the University of San Carlos. Under this manual, it is very clear that our client, Ms. Jennifer Seeley, since she was able to comply with all the requirements, she has the legal right to change her grades and to graduate cum laude. On the other hand, the university has a positive duty to revert the grades of Ms. Jennifer Lee from IC to 1.9 and to allow her to graduate cum laude. Next, we have here the material dates in our case. The date of the receipt of order from the President is on April 29, 1982. The date of motion for reconsideration is on April 13, 1982. And the receipt of order from the President is on May 4, 1982. And then the date of filing is May 12, 1982. Under Section 4 of Rule 65 of Rules of Court, which provides that the petition shall be filed not later than 60 days from the notice of judgment, order, or resolution, or when a motion for reconsideration or a motion for new trial is timely filed, then the 60-day period shall be counted from the notice of the denial of such motion. As we can see here, since Ms. Jennifer Seeley was able to receive the order denying her motion for reconsideration on May 4, 1982, Ms. Jennifer Seeley has until July 3, 1982 to file the petition. Since Ms. Jennifer Seeley filed the petition on May 12, 1982, the petition was seasonably filed. Thank you.
Good morning, everyone. As from the previous speakers, we can see that the Mandamus should lie. First, because it has complied with the rules of court, saying that it should be initiated through a verified pleading, and it must be accompanied by a certification against forum shopping. And also, as to the substance, as said by our co-counsels, the petitioner has a clear legal right. For a mandamus to lie, it is not necessary that it be absolutely expressed. It is already sufficient that it is clear. Here in our case, under the university policy, which is the fruit, a product of the exercise of a learning institution of its academic freedom, has stated quite specific rules or qualifications for the grant of Latin honors and for graduation. And all these have been complied with, faithfully complied with by Ms. Jennifer Lee. And also, considering the memorandum that was issued by the Ministry of Education, Culture, and Sports, it is clear that there was an order after the submission of all the requirements as required of the professors. There was no room for the exercise of discretion as to the grant of the Latin honors upon Miss Jennifer Lee. Indeed, academic freedom is very broad, but it is not without limits. It cannot be exercised so as to exclude a person from the enjoyment of a right which she rightfully is entitled to. It must not be exercised so as to amount to tyranny. This is not a doubtful case, as shown by the facts of the case, and so Mandamus lies. Give justice to Jennifer Lee. Stop academic tyranny. Thank you.
Thank you so much, Mandamus group. That was a really one-of-a-kind presentation. I guess this group is getting ready for evidence next semester. So before we move on to the critique, I'd like to call on Justice Yap for introduction of the panelists.